Okay, so this is everything apportionable? How to try an alternative apportionment case with unusual facts. I am Jen Karpchuk. I am a partner with Holland and Knight, and I am also an adjunct professor here at Villanova University. I am going to ask each of my panelists to introduce themselves and to also tell us a song title that describes our panel. Eric, you want to go first? I think you're the most eager.
I guess I hand it to the California guy first. So Eric Andersen from San Francisco, California. Really thrilled to be here. Love Villanova University. Great. This is a fantastic forum. We've heard a lot about California. We'll talk a little bit about California on our panel. I think my song would have to be Chappell Roan's Pink Pony Club. Because she leaves Tennessee with a dream, and everything in the song is unusual. So if you think about unusual facts, listen to the lyrics of the song. It's fantastic.
That was a wonderful choice.
I got to follow that. Okay. Is this on? I'm on. Okay, I'm on. Ocean Mills, managing director out of BlackRock, lifelong state and local tax person, originally from San Francisco, hence Ocean, Haight-Ashbury. I'm going to have to go with ABBA, Mamma Mia. Here we go again.
I mean, why?
Good afternoon. I'm Marilyn Wethekam, and I'm of Counsel for the Council on State Taxation, and I'm very happy to be here. It's the first time at Villanova, and this is quite an event, and I'm very impressed. Prior to that, I was a partner in a Chicago law firm, and prior to that, I was an in-house counsel. So if I had to pick a song, I guess just putting my whole career together, I would just go with the Beatles' Taxman.
Good job. Thank you all for participating in that little activity.
Well, what's your song?
I would go with the apportionable portion of this and do Britney's Piece of Me. Okay, so our presentation is going to focus on 4 hypotheticals, and drilling it down to these 4 was quite a challenge in and of itself because we had a lot of hypotheticals and different opinions on which one should stay and which one should go. So these are the 4 that made the cut. So our first hypo is sort of our most boilerplate hypo that we have here. State A has a single sales factor formula. Company A has, what is that? It's cut off. 20%? 25% of its sales in State A, but no property or payroll in State A. Company X files in State A using the statutory formula, then files for a refund, invoking alternative apportionment and seeking to utilize a 3-factor formula. What arguments should Company X make in support of its refund, and what types of documentation will Company X need to provide? Who wants it?
I mean, we can kick it off with California again. We'll talk a little bit about California because California creates a great framework for alternative apportionment. But maybe we step back and say, the panelists before us, and this morning we had Professor Pomp here, and Pomp said that a single sales factor is, and he used a word, abomination. I've always used the word aberration. Well, I think Professor Pomp is right, and I need to be very careful in my language. An aberration is something that is unusual or out of the norm. An abomination is something that is offensive. If you go back to Mormon manufacturing, you look at what Iowa did when it enacted a single sales factor. The argument in the case and some of the underpinning of the case was that Iowa was creating an aberration, that it was out of step with the other states. And what the court said is, well, I'm not going to pick whether or not Iowa's rule is correct or Illinois' rule is correct. All I have to look at is what is the rule, and is the rule out of all appropriate proportion to the business activity in the state as applied to that taxpayer? And they said, well, no. That was deciding whether or not it was an aberration. But was it an abomination? And I think the question there is, if you look at very particular facts of certain types of taxpayers, then maybe you get to the position that it is an abomination, meaning that it is unusual, it is not just out of the norm, but it is offensive because there is something applying to particular facts that gets you outside of what would be, faithful to the U.S. Constitution. And then we can talk about UDIPA Section 18 as well.
I think I take one more step back as someone who's been involved in litigating some of these. Is the first thing I think you have to do is level set. So on the practical side, I think you have to say to people, this is not going to be easy no matter what you do. So you have to make sure that you have people's expectations. And I know we have people from departments of revenue, and we also have a corporation like that's on either side of the table. You need to level set and figure out what your expectations are. I think the other thing you need to bring as a practical side to this is, and this goes for all of our hypotheticals, and we did have a very hard time narrowing them down, is they all are unbelievably fact intensive and they're going to take time. So unless you go into something with that as your background, anything we say today doesn't make any sense because you've got to go in and level set.
Well, and I was going to say, as the corporate taxpayer sitting here, it's easy to get into these philosophical arguments, and we've done a lot of that today, which is like super fun for like the brain side of this. But as the taxpayer, and then you get in there with counsel, and they're like, we're gonna argue this case. Great, what do you need? And you get in there, and it's like, well, I don't have those forms, and I don't have those contracts, and oh, actually, it's a different legal entity that signed that contract, and not the entity that's being audited. You know, and you really have to like step all the way back and say, do I have the documentation and the facts to really support this? Because invariably, you start off in the litigation, and by the time you get to the end, all sorts of creepy crawlies have come out of the woodwork as to your actual facts.
Yeah, and I think when you get to the idea that we're trying to prove something that is so distortive, something that is really unusual, something that is really, again, using the word abomination, it is hard. You do have to have the facts to support that. I think a masterclass in that is something that was talked about earlier today, which is the Smithfield case in California. I mean, if you look at the sufficiency of proof that is necessary to show that is something out of all appropriate proportion to the activity that is going on in the state, you really have to look at what the value is and the value drivers in the business. That's very industry specific. If you look at hogs being slaughtered outside of California, how much value is that relative to the market for the product that ultimately winds up in California? That's the underpinning of the Smithfield case. If you look at AI applications and the AI industry, there's a lot of value that is created by the code, by the bot trainers, by everybody that is doing what they are doing in creating that value that ultimately gets to you when you're using Google Gemini or when you're on ChatGPT. So those value drivers need to be taken into account, and by not having a property or payroll factor, they're not taken into account. So this fact pattern is a good one, but it doesn't give you enough of the facts. It doesn't give you the underpinnings of the information. What Ocean is talking about is, you have to have that documentation. You have to have some level of proof. And really, that starts at the position level of when you file your tax return and understanding what those facts are.
Well, we don't in this decide whether we're talking about tangible personal property or we're talking about service. And the analysis of what you're going to do is going to differ, I think, based on what we're doing here and what the value drivers are. And one of the most important things, I think, is you have to understand your business. You would know this in-house better than I, but you have to fully understand your business and have to be able to present that in a cohesive manner and explain it to prove the value drivers out.
No, absolutely. And I think it's one of the things that corporate tax departments internally fail on, because they're trained in the great halls of Villanova and other institutions, and you walk away with the law and the statutes, and you get hired and you sit in the back office and you toil away at the tax return, but they're not out in the front office. They're not out on the slaughter floors. They're not in the trenches seeing how the business is actually being run. And so they take positions on returns without really understanding the business. And that's where I think you have to make sure you understand your business before you take positions that could end up in litigation.
So to follow up on that, if we're talking about, one of the questions is what kind of factual patterns or what kind of facts do you have to put forth if you were going to litigate this so you could get it into evidence? One of the things then you need to do is go out to your business people and say, please explain this, and potentially what you could end up being is a witness. And if you want to see people run the other way, they do. And suddenly when you start going down this road and maybe taking interrogatories and answering all the great discovery problems that are out there, you find out things, as you said, creepy callers fall out. But you really do need to rely on your business people and have an understanding of that. And so that's one of the facts that comes out, and you need to be prepared for that.
Absolutely. We recently had a matter before the IRS, and we had the business come testify. And it's important, it's not just you have a business person come and talk shop, because they're going to use their acronyms, and the tax authority is going to get lost in the acronyms and what's happening. And we do this. We assume knowledge. We're doing it today. People have been using acronyms, and people have been using cases. And there are people in the audience who don't know these items. Maybe they're students, maybe they're practitioners that only deal in certain small jurisdictions or are sales tax, not income tax. You need to have someone who can speak, like I always say, with the sharpest crayons. That it's something that everybody can understand, and break it down to a level where you don't lose the judge, you don't lose the tax authority, and you are able to then translate what they're sharing with you into the tax law.
I love the sharpest crayons. That's fantastic. It's kind of like a little art project, right? California, in 2006, we had the Microsoft decision, which was a decision about distortion. And there are really two levels we talk about with distortion. There's constitutional level, which is, out of all appropriate proportion to the business activity in the state. And then there's the statutory distortion, which is maybe a rung under that, which is whether or not there is fundamental fairness in the application, just paraphrasing. If you look at the Microsoft decision, they separated out two pieces to the distortion analysis. One was qualitative and the other was quantitative. Quantitative distortion is how much. Okay, well, we can get our arms wrapped around that. If you look at some of the cases, there are some comparatives that are in Hans Rees and others that we've talked about. But if you look at qualitative, that's really what we're talking about here, is how do you actually get to what that business activity is, and how do you get to what that value driver is? The Microsoft decision concerned whether or not you could put treasury receipts into a factor common with software. And the treasury receipts accounted for about 73% of the sales factor, whereas software accounted for the rest. Well, treasury receipts accounted for a very, very tiny component of the actual income in the business, even though they had so much of the business from the other side. So when you put those two things together, you got distortion. There was a value driver from the software that was then not really being taken into account because so much was being bled off in the treasury receipts. And that was a California win on distortion. And California did a very nice job, and I will give a shout out to the states because they do nice jobs in many cases, of actually showing what those value drivers were from the software and how that did not relate qualitatively to the treasury receipt side. So I think looking at those value drivers, get to know people who do valuation, who do economic analysis. There are economic analysis firms that are out there that can look at the value drivers of your business, of all your different distribution channels. If they're not being taken into account because there's no property or payroll factor, then I think you can build a case.
I think when you're looking for value drivers, it may be property or payroll, but is there another value driver out there, which could be intangible property, that you would have to fashion a factor around? And that's, in some ways, we're talking a little bit about doing an economic analysis that looks a little bit like a quasi-482 analysis. It's the concepts are somewhat the same. And what are you actually utilizing to generate this income? And so you have to fashion, because part of, assuming we're not going for constitutional distortion, we're at the 250% or whatever Hans Rees says, you're looking at under Section 18, which in California is 25,137. If you're looking under that, you're looking at it doesn't reasonably reflect, I believe is what it says. So what are your value drivers, and can you fashion a factor that does it? Because the flip side of this is you have to come up with a reasonable alternative. And that's what we're going for here. What kind of documentation can you get to a reasonable alternative?
Yeah, I was going to say, go find your transfer pricing person. That was my first thought, because they're the ones who actually understand the business and do the internal valuations. And it's interesting because we have a very robust transfer pricing team. My little shout out to my guys, and they do an analysis where they weight the head count. And it's interesting because they're not apportionment people. And so I'm always like, oh, we do that. We've got payroll. And they're like, no, we weight the head count. I'm like, what do you mean you weight the head count? They're like, well, your CEO is making $30 million a year. Does he really drive more value than your programmer who's getting $100,000 a year? And it's like, well, wait a minute. The programmer is actually creating a product. My CEO is running around and driving business and policy, but there's a different weighting that has to occur based on what they're doing and the business that they're supporting. And so they have a lot of this detail. They have a lot of information that's very, very helpful to understanding the value proposition.
Great. Okay, so we started off pretty basic here. We're going to move to some more unique, interesting situations. This one actually is one of our hypos that almost got cut, but then we started talking about it on our call and started to, realize it was a little bit more common of a unique situation than we were originally anticipating, so we kept it in. So Company X has a significant number of government contracts which are provided to locations throughout the United States and worldwide. All the invoices are sent to the Department of Defense Procurement Office in State C. For national security reasons, they cannot disclose the locations of delivery. State C attempts to source 100% of receipts to the state based on the invoice address. How would you respond?
I actually had a case that was somewhat similar to this. It wasn't that kind of sourcing. It resulted in throwback. So I guess the first thing I would do with this is we need to distinguish what type of business this government contractor's in. Are we selling tangible personal property or components of something that's going to be incorporated into tangible personal property? Are we talking about services? What are we talking about, a mixed bag of that? Because when we start analyzing this, you're looking at it, the analysis and where this could be sourced is going to be different, I believe, with respect, because we're dealing with government contracts. So that would be the first step I would look at. Is the other thing I think, going back to the matter that I had, I don't think that the taxing authority fully understood the nature of the business. And while you have government secrets and there's all sorts of proprietary information and things that you cannot disclose, there is a way at some level to explain the details of the business. And so that's where I would start, with a detailed explanation of the business operations.
I agree. The next thought, though, is putting the auditor hat on. It's like, that's nice. Well, then why is my 100% to my state the wrong answer?
Well, it depends on this. The other part of the business is, where are your operations? And let's assume that you're making fighter jets and State C doesn't have a base. Your pretty odds are that that jet isn't going to State C. I mean, so there is some advantage to explaining where your plants are, what you're doing, and at a level where you're not disclosing something that would, I think, violate whatever your government restrictions are.
Yeah, in Maryland, I had a similar situation to that, where it was a government contract. It was there were classified contracts. It was very clear, even with the classified nature of the contracts, that what the contracts related to were surveillance systems that were surveilling areas that were in war theaters. Well, the last time I checked, there was not a war theater in the United States. So if you think about where the benefit of the services that went into the engineering, that went into what they were actually providing to the federal government, it had nothing to do with a benefit within the United States. And if you're in a state that has a market sourcing rule where you are looking at where the benefit is received, or even where the service is delivered, I don't think you would get to a billing address answer. And yet you're constrained by the information that you have. So is it enough that you could show the information of what the type of product or the type of service it is, and where that would reasonably relate to in the geography?
One of the things we did, and this may get a little bit more granular, we went to the business units and we went up high enough up the chain, and we got affidavits from people that said, we are manufacturing, we didn't necessarily say what, but where these are used as components and then incorporated into here, and where our manufacturing is, and that kind of carried the day, to be really honest, was the affidavits.
Yeah, and there's some backup to that in some of the regulations. If you look at, so California is going through a regulatory process, and Marilyn mentioned 25136-2. Well, 25137 is the alternative. 25136-2 is sales of other than tangible personal property. It's a market-based rule. There's a cascading set of presumptions in the rule. We've gone through several interested party meetings. The regulation was first proposed to be amended in 2017. It still has not been put out yet. They pushed the applicability date to it off into 2026. But it has a rule for government contracting for this very purpose. And there is a component of the proposed regulation that talks about that any reasonable approximation of where a benefit would be received would have to relate to the geography to which it relates. And I have an interesting story going back to 2014. We were dealing with a situation with very little information about satellite transponders, and a client that used satellite transponders to survey the Earth, and surveyed the Earth for a variety of different applications, part of which was military, part of which was just topography and map making and other things. And we got into a tangle on what reasonable approximation meant. And our argument was, well, the state of California is 0.0042687% of the Earth's surface, and that's what this surveys. And of course, the state of California didn't like that. We had a very good exchange and a good back and forth. I won't talk about what actually the ultimate outcome of that was, but it was a very good exchange. One of the parts of that exchange was, well, you don't survey the entire Earth because you don't survey the oceans. That would be ridiculous. And then a Malaysian airliner went down in the Indian Ocean, and our client's satellite imagery was used to actually find the wreckage in the plane in the ocean while we were having that discussion with the state of California. So in fact, they actually did survey the oceans, and that was part of the geography that was relevant for purposes of dealing with a reasonable approximation. So there's a lot of creativity that we can have, and I think notwithstanding that there may not be good documentation, you could find reasons and facts that back up using a methodology that has some reason and connection to the geography that would be your population to create your percentage.
Do either of you have any fun, unique ones that you want to compete with Eric on? That one was pretty good. Nope, moving on. Okay.
But this is one other comment about this too. We've focused on defense contractors or government contracting, but there's a lot of industries that don't have good information. Cryptocurrency, you don't know where the people are that you're dealing with. AI, you don't know necessarily where AI users are. Any type of software user, we had the Wawa decision that came out here in Pennsylvania, sales tax decision that dealt with multiple points of use. I mean, one of the arguments that the department put forward is, well, you don't know that your customers are actually accessing the software that is used at the POS in each of the Wawa stores. And the tribunal said, well, gee, it's pretty reasonable to say that software is actually used at the point of sale. So in that decision, Wawa won, and I wanted to bring that up because we don't have Wawa in California. I like saying Wawa. I like going to a Wawa. I like Wawa sandwiches. So it made me very happy to have a decision named Wawa that I could talk about today.
Very good. Okay, moving on to hypo number 3 here. Company X has limited operations in State E. State E seeks to include dividend income from Company X's foreign subs in its tax base. What are some arguments that Company X should raise? Marilyn, you want to start?
Oh, sure. I'll start. Well, I think the first question you have to ask yourself, and this really may not get to I guess it does get to the apportionment side of it, is how does the state treat other dividends? Are they excluding domestic dividends? Are they excluding, you're talking about foreign dividends, but if they're excluding domestic dividends, you fall right into craft, right? So, that's the easy way out of this. You just put yourself into somewhat of an unconstitutional position, and we're not going to debate footnote 23 in craft. But it's very important today when we talk about guilty and a push today to increase the tax base and put more foreign source income in the tax base. And Illinois obviously just did this within the last week. And so I think how you source this has become much more important. But I think the first analysis is how you're treating the rest of the other dividends and other distributions.
No, I agree. And I think the jurisdictions struggle with it because they like to see the increase in the tax base, but then kind of the default, at least in my mind, for foreign dividends is it's just denominator. It shouldn't be in the numerator. This is receipts from your foreign operations. These are your CFCs. They're operating overseas. We won't even get into the 965 universe. But you've got, customer receipts. If you go all the way down to my French customers, they're not in Illinois, and so they're not in the numerator. And you'll find that the jurisdictions are suddenly faced with factor dilution, and are they getting enough juice in the base addition?
So now I'm going to get mad. And here's where I'm going to get mad. I'm mad at my own home state. We had a wonderful decision in Microsoft that came out in 2023. And in February of 2024, the Office of Tax Appeals decided to not rehear it. And that decision said that when you have a water's edge dividend, you have a dividends received deduction. So you get $100 of dividend, $75 dividends received deduction, $25 net dividend. Franchise Tax Board says that $25 goes in the tax base. Microsoft said, my gross receipt was 100. Wins on the basis that it should be the 100, the gross receipt, because that is the gross amount that goes into your sales factor. So we get this great decision. What happens? I love hearing from somebody in Pennsylvania saying, gee, it takes really long to get things done. 4 months later, the California legislature and the governor signs a bill that effectively overturns the OTA decision. That bill says that anything that is not included in net income does not get apportionment representation, even if it is a gross receipt. But let me read you what the language is of what is not included in net income. Not included in net income for any reason, including by exclusion, deduction, exemption, elimination, or non-recognition. Deduction? Did California just become a net receipt state? Do we take off cost of goods sold from our gross receipts because now you have deduction and it's not included in your net income? I mean, that's effectively what you have with the water's edge dividend. You have a deduction from your dividend because you have a dividends received deduction and your cost of goods sold is a deduction. What else is a deduction? So in building some of the cases, we talked about the fact side of things where, yes, you need to understand the underlying drivers of your business. You need to understand the underlying facts of your business. But sometimes if we look at the statutory language that is enacted, we make it to a statutory argument that, gee, not only should 965 and other things be treated as a dividend, but that dividend may be subject to a dividends received deduction. Maybe you have some kind of a case that Marilyn is talking about. But then when you get to the place where you have to have factor representation, having a no representation at all seems to be nonsensical. And that's exactly where California's gone. By the way, that law is retroactive to the beginning of time. The original promulgation of the statute was 1965. California would say, well, it's really only retroactive to 2006. We will see. We have 2 lawsuits that are pending right now to challenge that legislation. But I think we admire the statutory language, and there are cases that can be built around some of this language.
Well, you go back to container, internal and external consistency, but there's language in container that the apportionment, to the fact that if you put income in the base, there is some representation that needs to be in the factor, and that's why it was reasonable. And there's a footnote in it. I think there's also a footnote in Mobile Oil in a dissent the same way, that if you're going to tax the income, it should be in the factor as well. So there needs to be some synergy between symmetry between the factor and the base. And when you start putting 50% of GILTI in or 50% of foreign dividends, you're out of all proportion to that, and you may have a double tax problem too. But
well, it just got me thinking, in a totally absurd universe, are we saying that if I'm in a loss position, I have no factor? I have no net income?
And don't do this. I have seen a tax return where you take a loss and you have a negative factor and suddenly you wind up paying a tax. I don't do that. But yes, it makes no sense. It makes absolutely no sense. You know, one thing that is interesting. So, Jen, I think your song was "Piece of Me,"
yes,
right, from Britney Spears. Okay, I'll throw another one out. Gimme more from Britney Spears. So the Moore case, a federal case that talks about Section 965. What is 965? Well, they said, well, 965 is fine because 965 is effectively like a pass-through. And they actually said that they're using kind of an attribution theory. Well, what does an attribution theory mean? Well, all that means is that all the income from your foreign subsidiaries that is now being dumped into your federal income tax return is effectively flowing income through those foreign subsidiaries into your U.S. tax base. Well, why wouldn't you then flow up all your factors related to 965? I think we're going to have this fight. In fact, this fight is going on in Nebraska right now with Precision Castparts because Precision Castparts lost a decision to say that 965 would be subject to the dividends received deduction. The court said, no, it's not really a dividend, it's something else, so you don't get your dividends received deduction. So now round two is going to be, all right, 965 is in the base, what goes in the apportionment? And I think backing up to, well, what created the 965 in the first place, there may be a really good argument there.
I think you could have the same thing with guilty, because the theory behind guilty, or the proponent's theory behind guilty, is that it really is displaced U.S. source income, right? And so if it is truly U.S. source income and there was a sale that generated that income, or there was property, assuming you still had a three-factor formula, there was property or payroll that generated that would be reflected in the factor. Now, the fact it's probably going in the denominator, to your point, Ocean, is probably one of the issues here. So if that's the argument, then there should be some representation in the factor. My point would be it's not net guilty. It's the underlying factors that generated that income, because that's what it would be in the United States if it was truly displaced U.S. source income.
So as a litigator, how do we get the proof of that?
Well, you go see your federal people first. I think, and guilty, I think they can pretty much, I haven't looked at a return in a while, but I think you can pretty much go back and kind of trace it, because obviously you do guilty while it's on a consolidated basis, you know what's feeding that in, so there's got to be some backup to that.
You can see the income, and you'll get the gross from the CFCs.
And you would know what the CFC does, so you would know what its payroll is. You might have to convert it, currency conversions, but you would know what its payroll is. You should know what its property values are, or something close to approximate.
Yeah, so thinking about this, let's go back to when we're building our positions, when we're doing our work papers, and we're creating our returns. The litigators need to rely heavily on the accountant. So if you're a tax preparer in this room, that is absolutely essential to building the case, because the lawyers don't necessarily know the guts and the mechanics of filling out the tax returns, and that information might be there, and you're absolutely necessary to that process.
And if counsel gives you a cite for why you're sourcing something the way it is, don't say as per Ocean, put the actual cite in. I did have that once. I'm not substantial authority, please use the cite I gave you.
I think, to prove this up, you're going to rely both on your international tax people and your federal tax group to back up the information, and then you're going to have to explain that on audit. I think it's better to do it contemporaneous with the return than trying to do it 3 years later when you're under audit.
3?
Well, I'm giving people benefit of the doubt. There's, it could be 10. I know.
So now let's maybe talk about something a little bit different. So we have the inclusion of income coming from other sources. Maybe it's outside of a state, maybe it's outside of a country. In this case, we're talking about dividends coming in. What happens when you have margins that are wildly different, either between different types of businesses, or you have margins that are really different just outside of the country? I was dealing with a client that had margins outside of the U.S. that were about 1/4 of what they were being able to command in the United States on about the same amount of sales. So if you are pulling dividends in to the U.S. and that relates to a certain amount of earnings and profits from outside of the country, and your margins are very thin or much thinner than they are in the U.S., then the gross receipts that created that income, that precipitated that dividend, is much, much higher than what it is in the United States, where you have a smaller margin. So now not only should you have more representation in the base, but it even should be supercharged in the base, because you have so many more receipts that created that EMP to create that dividend.
And you've got Microsoft.
And you've got Microsoft, which talked about margins.
And I think you have Container, which talked about the cost of paperboard products down in the generating and paperboard products down in South America, which was the payroll obviously was considerably less than what they were using when they were trying to put it in California. So it diluted the denominator of the factor effectively, and the court really didn't care.
And if you ever want a good analysis of anything related to footnotes, talk to Marilyn. I think you know every footnote of every case I've ever seen.
The meat is all in the footnotes. That's what a law school professor told me. You got to read the footnotes. I'm like, really?
I think I had that guy.
Yeah.
On to our last one. Okay, hypo number 4. State B is a separate company state with COP sourcing. Company X files in State B, but related company Y does not because it does not on its own have nexus with State B. Under audit, State B's Department of Revenue invokes alternative apportionment to force combined reporting. If anyone has read Tractor Supply, you know what state we're talking about here. How would you approach this case, and who has the burden of proof here?
Well, typically, though not always, the party invoking alternative apportionment has the burden. So we'll start with the easy part there.
Here's the softball.
Yeah, exactly. Though I've encountered states that don't always take that position.
Agreed.
So I say it should be the case.
So, all right, I have a twist to that, and this one I don't think I've seen litigated. You're right. I mean, I agree with you. I think the MTC regs say that's where the burden goes, and there's some case law in California that says it as well. But generally, when you get an assessment, it is deemed prima facie correct. And so, generally, as a taxpayer, you're the one that has to overcome that burden, and then you can flip the burden, obviously. So in this situation, who really has the burden? And that is not what I've seen, because effectively they're saying, we're going to do this combination, and we won't name the state. You're going to do this combination. Technically, that would be prima facie correct, I think, when you get the assessment. But now what you're really arguing for here, I believe, as the state, is alternative apportionment. So you have some tension between the two. I've not seen that, but I keep waiting for that to pop up someplace.
Yeah, and one thing, just going back to what you were saying about the presumption, I think there's probably a difference. There is a difference when you're thinking about when you're at the administrative levels, you're going up to a state tribunal that is not a court, or if you are going into an actual court of law. If you are at an administrative level, you always get the argument back, whether it be a brief or a position paper or anything, that starts out with the state has the presumption of correctness. Always. Even in a state that probably doesn't really follow that, I think that I've seen that just across the country, that they have the presumption of correctness on the determination of the apportionment factor. And Ocean, to your point, that's absolutely not true when you're talking about who is invoking an alternative to what the statutory formula provides. The presumption is not there. It should be who the moving party has the burden of proof.
So with that being said, I totally agree with you. I keep waiting for this other one to pop somewhere along the line. So now the state has the burden of proof. I mean, we have the standard of burden of proof. Is it by preponderance? Is it by clear and convincing or evidence? But what you're dealing with here, and then we talked a little bit, they talked about, a couple panels this morning talked about this, but what you're dealing here would be, you have to establish a unitary relationship. If we're talking about the state that we're not naming, you have to develop a unitary relationship. That's a fact-intensive process, and we all know, to get to where you're at. So what's involved in doing that? The state really, now you as the taxpayer are going to get the IDRs, right? I mean, that's...
Oh, yeah. No, well, and it's also interesting because if the state is invoking the alternative, they've presumably said there's distortion here. This is why we have to go to a combined filing. They don't have the facts because, well, they're the tax authorities. They don't, and so it's an interesting tension for them to be in a position of needing to have the burden of proof when they don't have the facts. But then, yeah, you have to go through and say, no, there isn't, we don't have, common management. There are separate management companies and we've got different CEOs, we've got different, and I have found at least a lot of times those arguments aren't persuasive. They're like, well, yeah, but the numbers are too out of whack, and therefore it must be that we've got this right.
Well, you almost have to take a step back because this is a cost of performance state. There are not many of those left. So if you're thinking about a cost of performance state, you have to identify the income producing activities first before you ever get to I would think, the unitary analysis of it. So I would think now you have to prove up your income. What are your income producing activities? And then where are those activities? Where do they occur? Is step two. And then how are they related to the rest of the members of the affiliated group?
Unless you're in South Carolina.
Right.
The state that shall remain nameless. Yeah. I mean, one of the things here is some of these fact patterns are, we made them necessarily a little bit vague just to think, well, what lies beneath the surface, right? Well, what if company X is providing the services to company Y? What if company X is actually providing those services on a cost plus basis? All the margin is in company Y. So maybe the state has a point. You've extracted all your margin out into company Y because you've isolated company X into its own company. That's the only filer in the state. Notwithstanding cost of performance, assuming company X is doing the work in that state, that would drag, presumably the apportionment and the apportionment of the income in the state. The base is very low. But I think the defense to this is statutorily, is there a basis for there to be a combination? Because if you think about what combination is it a method of apportionment or is it something else? And that is one of the arguments that has been bandied about in South Carolina and some of the other states, which is, well, fair apportionment first requires that you determine who the taxpayer is. And if the taxpayer is company X, then you look at company X's apportionment. And sure, you can futz around with cost of performance, you can futz around with something else, but if we're really messing with apportionment, that is not base. Base is, do you put the whole thing together into one common base, and then you apportion everything together? So there could be a debate about whether or not we're talking about a method of apportionment or not. And I think there's a very good argument that if you have a state that does not provide for combination in their rules, and that is not provided in state law, then combination is just possibly out of the question.
You also get into a situation where if you've got very robust transfer pricing in place, where it's all arm's length, it's fair market value, and so you are acting the equivalent of a third party. And so now you're saying, we're going to disregard that. You aren't really a third party because you've got economies of scale or whatever we're going to argue. We're going to pull you together. Well, now you've eliminated the intercompany transactions that are happening, even though under 482, they're real arm's length transactions, which should be going into the factor and all the other good stuff.
Yeah, and I think that's the difference between do you have a 482 question or do you have an apportionment question? Because combination is something different. I would say the focal point should be in 482. If the 482 is wrong, fair. If the 482 is reasonable, then you are following faithfully what the state statutes provide.
I would agree with that. I'm not sure that Section 18 authorizes combination because I think you have to get to the base before you apportion it. And I think additional support would be, if you go back and you look at the comments from when UDIPTA was drafted, which is 1957 or something like that, and some of the articles that were written around that time, it's clear that the state should know what their base is. What we're dealing with here is how to apportion the base. And so, I mean, William Pierce is who wrote the article, but it was how you apportion the base. So to your point, Eric, it should be like a 482 type adjustment. Adjust the base. If you don't think the income is being spread correctly, and I think if you even went back to like Butler Brothers, they were really putting the base together. They weren't trying to apportion it yet. And so I'm not sure that it supports that. And I think maybe the misnomer in South Carolina is in media general, which I think started most of this. Both parties stipulated that the standard factor did not correctly reflect the income that was being apportioned to South Carolina. But more importantly, both parties stipulated that combination was the right alternative apportionment. I'm not sure they ever got to the actual issue. The question was whether they had the authority to do that or not whether it was the right thing to do. So,
And sort of touching on the transfer pricing reports, and if we're thinking about Tractor Supply for a second specifically, there the court said essentially they're flawed and unreliable, quote, unquote. So I guess touch a little bit on that in terms of documentation, thinking you have documentation, what should you be doing, what should you be reviewing in anticipation for these types of cases?
Well, and that one's a tough one because 482 studies are not conducted and performed internally. You don't just say, hey, Bob, go do this. You engage, a third-party accounting firm, valuation firm to go in, and they do a robust review, and you pay lots of money for these things. And you get all these pretty binders that sit in someone's office, mine. And so, you think at the time it's a contemporaneously prepared documentation. You think you've done it correctly. It's a reputable firm. Everyone knows the name, and you think you're good to go. You fast forward, however many years, and you find yourself in litigation with a taxing authority who says, yeah, no, we don't believe it. We think it should be in the upper quartile, or no, it's too far on the upper quartile, or you're like, now what do you do?
So let me ask you a quick, would it be better to get a study every year? I mean, would it be better to update them every year rather than some of the ones I've seen have been sitting around for collecting dust forever? I mean, my understanding is if you're in the CAP program for federal tax purposes, you may have to turn over a study every year. I don't know if that's actually correct. I had a client tell me that, a former client.
It's hard because when you're in the CAP program, it's a contemporaneous audit. Like
Right.
You're in live time, and the studies don't happen that fast. So it would be surprising that you were turning over a study as your year was progressing.
Or updating them, maybe.
Yeah.
Yeah, I mean, I think that's a good point. Do you actually do that contemporaneously? Because contemporaneous documentation comes up over and over again in a lot of different contexts, and 42 is one of them. I mean, this kind of goes back to, again, the whole principle of the value drivers in the business. I mean, that's what 482 is all about. Is how do you figure out the economic value of somebody doing something for somebody else, regardless of what that thing is, and what I have seen a lot of is I see a lot of, well, we'll just do a cost plus, right? We'll take the cost of our people that we put into this entity and just mark it up with some percentage, call it good, and then you have somebody kind of lightly bless it without doing a full economic analysis. I think it behooves you to do a full economic analysis of what the value is that is being provided and look at third party actual transactions that are comparable to yours, which is what 482 really compels you to do. And I think where things fall down in the documentation is, and I've seen this in a lot of transfer pricing reports, is a lot of caveats. Right? Okay, we looked at this, but we can't really opine on a certain thing, or it's limited to certain information. We didn't consider other information, and you'll see that again sometimes in footnotes, Marilyn, your favorite. So I think you really want to understand what the full scope and how the documentation looks. There have been, in some of the 482 cases that are out there, the courts have made these kind of nasty comments around what is in the report and what the report was labeled and some of the language that was used that indicates that the report might not be as reliable as the taxpayers purporting it to be. And so I think not only getting your documentation to look at those value drivers, but to have it really laser focused with the language, to be careful about what it says, so that when you do get into litigation and you do have to hand over the transfer pricing report, there aren't a few nuggets that are lurking within it that they could impeach it in some way.
I do think, though, there's a little bit of hindsight is 20/20 in that, because when you do the study, you have kind of a rosy view of the world. You think everything's going to be fine. You're doing this because it's important and it's necessary, but you don't know what the auditor is going to pick up on, what component, what value driver don't they like. And so there might be language in there around that one particular item that at the time the study was done, you thought, well, that's a small piece, like who cares? So it's hard to keep in mind kind of the pantheon of problems that could be coming down the road at you. But it's also, I think, we keep going back, and I just kind of had this thought just now of the value drivers, and it goes back to this morning's panel with Professor Pomp of, knowing where the value is happening. And when you have a transaction with an affiliate, with a subsidiary, with an intermediary who's not related to you, trying to go all the way down that supply chain to the actual beneficiary of whatever it is you're doing, and having that whole line of information available to you is just about impossible.
When you talk about transfer pricing studies, do you think it helps if the transfer pricing study was actually done for purposes in other words, it was a federal transfer pricing was done for federal tax purposes rather than some of the ones that I think were being attacked in Tractor Supply were done just at the state level? Is that, I think that's my understanding. Does it help?
I think it helps. I think, and I see this at the federal level. If you do something at the state level, the feds appreciate it because they know that you did it for reasons other than their tax code. If you're doing something at the federal level, the states appreciate it more because they recognize you're doing it for the Fed code, not their code. So if it's not directed at a particular jurisdiction's tax regime, I think it has more weight. If it looks like you're just doing it because you think there's something hanky going on here, they're going to have more skepticism around the study and the purpose of it.
Yeah, we had one situation about 10 years ago that I was dealing with where there was not a transfer pricing study of sorts. There was a transfer pricing study light, I will call it. But what it was built on was a management report that was used to spread out income among the different this was retail stores, and there was an economic analysis done of how much value those retail stores created based upon their sales and other things. So because of that, the state that we were dealing with was more accepting of what the transfer price was because it was built on a report and economic analysis that was used for a purpose that was non-tax. And that may be helpful. So Marilyn, to your point, when a judge is looking at a transfer pricing report that says state tax minimization review, that may kind of cause a little bit of an ire with a state judge relative to you did something for a different purpose, or you did something that was required for federal income tax purposes and then extended it to the state.
Though you do have to be careful because I've seen at the federal level they like to use minimization of state taxes as the business purpose, and I'm always like, that's not a business purpose. You don't get to minimize your state taxes.
Yeah, maybe it is for them. It's definitely not for us.
What you're saying is we have to watch the wording in these studies.
I mean, I think the interesting thing with a lot of these transfer pricing cases, and it came up again with this case, is the Department of Revenue isn't getting their own transfer pricing report in a lot of these instances. They're expensive. They require expertise that they're not going to have in-house. So, especially with this one, you're relying on the one that you had from years prior that were under those, rosy-colored glasses. I guess if you're in that situation and you know that the other side hasn't produced a transfer pricing report, you only have your own. Do you provide another expert to review that and perhaps provide their own opinion? That could be another option for the judge.
I think it's a great idea, and it's actually something that we did in one case where we had a very old transfer pricing study. It was done contemporaneous with a transaction that had occurred, but now fast forward, the transaction's unwinding, and now the end results people aren't really happy with, and the tax authority brought in their expert who was in-house, and so not necessarily versed on the financial services side of the universe and loans and subpar debt and all sorts of crazy hybrid structures. And we had another party come in and basically give advice to both sides and say, okay, here's how the study worked, here's what the transaction was, and explain everything. And the judge actually did appreciate that very much.
I had a similar situation where we were involved in one where the transfer pricing study was done when a transaction had done, a restructuring had been done. It had been done for federal purposes, and the transfer pricing had been done for federal purposes. And then about 10 or 12 years later, they were having an issue at the federal level and had another come in on top of it and validate what had been done. and it went miles with the states when they came in to challenge the same transaction. So I think the answer to your question is yes, that if you can put in, you can always have you know this, you can always have an expert at trial, then you have dueling experts pretty much. But yes, I would, depending on the price of things and how much tax you have at stake, I definitely would get a second opinion, I guess, is what I'm saying here.
So maybe I'll loop this back around to something, Marilyn, you said earlier when we were talking about alternative apportionment and apportionment representation, which is what about intangibles, right? And a lot of the 482 studies deal with what is the value of intangibles because you have cross-licensing around the world, around the states. So if we are going to go down the road of there needs to be apportionment representation for all the drivers, the value in your business, and intangibles is one component of that, the people, the economists that do the 482 studies are invaluable in figuring out what that value is for the intangibles that are used in the business. So if we're going down the road of building a case, even an apportionment case, you may rely on some of the people that do something completely different and in a different discipline for that purpose.
Well, I think you could take that study and convert it into some sort of a reasonable alternative factor, right? In the end, to have alternative apportionment, if you're raising it, you have to come up with a reasonable alternative method and that may be one way to get back into it, I guess is what I'm trying to say. Yeah.
On our last 4 minutes here, do you each want to touch on your biggest takeaway for our panel here?
You know, I think, I think the big thing here is we touched on, again, some of the statutory issues and some of the proof issues, and when we get down into the details, and maybe hopefully I'm not stealing your thunder, Ocean, but I'm just going to pare it back a little bit of what you said is get to know the business. You know, it's really, Ocean is in the business. I'm not in Ocean's business. I don't have as much of an appreciation for the business as she would, being an insider to it. So you get, as advisors, we get one step removed. As state people, not knowing the businesses because you're not in it, you're one step removed. As accountants, you're one step removed if you're an advisor to the company. And even you, I think you're a bit removed from the actual operation of the business, but you're closer to it than we are. So I think it's really easy for advisors to kind of reach their hand in through the curtain and give a PBC and say, please give me this information. It's a different thing to actually go to the plant, to actually go visit the stores, to actually go visit the people, to interview the engineers. I have a great admiration and some jealousy for some of the people that do R&D credit studies because they really get into the guts of the business of what people do. They interview the engineers. They talk about what the processes are. They understand the IP. They understand the development. They really get into the nuts and bolts of what is happening at a very granular level in the business. We don't generally have that luxury. But if you're going to build a case for some kind of a different apportionment, a different construction, we need to do that and really get behind the curtain.
You're absolutely correct. And my brief time at the law firm, it drove me nuts because one day I'm dealing with Georgia used tire tax, and the next day I'm dealing with airlines, and the next day and you're all over. You're schizophrenic. You never know what you're dealing with. Whereas being in-house, I get to see the inception of the seed, and it grows into the tree, and you get to see the entire operation. But even being back office, as us tax people are, it's incumbent upon you to know the business, to understand the industry, to know where our trends are going, et cetera. But I would take what you just mentioned, and I think this is important for practitioners here, is when you're building a case, ask your client for maybe an R&D study or the transfer pricing study. It might not have any relevance to the actual matter that you're litigating, but you might find in it information that's helpful to understand their operations, to get a better sense of how they do what they do, because you're not going to be able to do a crash course on their 150-year-old operation, overnight.
So to build on that, I think the one thing that I would say is when you get into one of these as a practitioner, you have to go back to the client or whomever and say, what data sources are available to you? What data sources are available in-house You may have some proprietary issues with respect to things. What resources can we gather from business units, from data that you have, from your IT group, whatever? And then also, I think you have people around you in-house that know what third-party data sources are out there. And there's a lot of third-party data sources I don't think we utilize maybe as much as we should, because there's certainly agencies that tracks, depending on what industry you're in, tracks certain things, and you can pull that out. There's FCC licenses, depending upon what industry you're in. And how you can put all that together and start to build a case, and then build off of that. So I think sometimes you have to think outside the box for what's out there in the data capacity and utilize that.
Great. Okay, well, I think we are out of time here. I think we have maybe 20 seconds if anyone has a 20-second question they want to ask real quick.
I mean, just to wrap it up, you got to get inside the Pink Pony Club and see what's going on.
Thank you very much to our panelists.